a post-lunch session, sir. So it's a privilege to have someone like Advocate Sri RadhaKrisha Murthy. He is an eminent corporate legal advisor and consultant for many companies, and I can say they are the tycoons of the industry. If I take some names like Hyderabad Marriott Hotels, Sykes Business Services, Hyundai, IKEA, Amazon, ISB, BITS Pilani. So he's a consultant and as well as attorney for many of the companies and which are in different industries. Also, if I just give you a brief about him, he's a practicing advocate in High Court of Telangana and Andhra Pradesh, and his legal career started in 1987. So his areas of expertise are nothing but industrial relations, labor laws, employment, and corporate legal matters. Also, he has played a vital role in dealing industrial disputes with various industries, including pharma, and he was a regional board member of the Employee State Insurance Corporation, and he was also a member of Andhra Pradesh Minimum Wages Board Rationalization Committee, representing the employers. He's a lifetime member of Telangana High Court Advocates Association, Andhra Pradesh High Court Advocate Association, and he's a non-figure in HR fraternity as well to give the seminars and programs conducted by FAPSI, NHRD and SHRD. And let us have a big round of applause for him. Welcome him. Also, we have collected the questions, the queries, the doubts that we have, right, from multiple sector. So after his speech, we will be asking, we will be shooting this to him, and then he has to answer. Thank you, sir. Yeah.
Good afternoon to everyone. I think rest a while after lunch, walk a while after dinner. Are you resting now? Your lunch is over. You are awake. Now you got to arise awake until you reach the goal. The goal today is accomplishment what you learn here. Right? What is your idea about the session? Legal knowledge. Do you feel it is required? In what way it would help you? It is better
for smooth operations.
But can I use the collar mic? Collar mic. I took the collar mic because to be able, I should not be stable. Stand at one place, right? I keep moving. But they gave me the only this radius because otherwise they told me that I would be out of camera. So my radius is only to this extent, from this end to that end, right? Okay. Yeah, I always suggest prevention is better than cure because management is nothing but a common sense is most uncommon, law is nothing but a logic. If you have a logical thinking, you would be having the solution as well. Another thing is that the approach of law remains same for both the parties, who is prosecuting and who is defending. It all depends how you interpret. The interpretation comes out of analysis, how you analyze, how best you can analyze. Once if you analyze, you would be able to interpret to suit your case, and you put it and you present it how best it suits to your case, then picked up by case laws, case studies, examples, so on and so forth. So in day-to-day normally what is happening is that you will be having several issues, queries from out of your working life. You might be having an idea, you might be having a solution, but you don't know whether it fits into the legal compliance or not. By the same time, you also got to be careful in respect of the compliance while having. At times it is also very difficult to be too legal, but I don't suggest you to be illegal by the same time. Because you got to be within the ambit and scope of compliance as well. But how best strategically you can implement to suit the situation, because it has to sync with your business ideas. Then only you would be able to, because you ultimately you got to run the business. If it is a litigation of the individual can fight any long, but the organization or a corporate litigation will have lot of impact on the organization. It is not only have the organization and so many employees dependent on the organization, because I am highlighting the point of employees because you are all from HR. Am I right? Because HR means being human is more important than to be the human being. Do you agree with me? But at times we got to forego our humanity. You got to compromise. No need. You can do the counseling. But what I say is that if you know law, you would be able to mitigate the law. Mitigation of litigation is always best, because litigation is a speculation without knowing the destination. Pardon? That's good. Still anybody is sleeping? Because I am under speculation, you have done mitigation of that speculation, that all are awake. I thought somebody might be in sleepy mode. Right, that's good. Am I audible to one and all? I am just asking to just test whether you are sleeping mode or active mode. It's okay. That's why what you got to do is, in most of the cases what I come across is due excuses, especially for the youngsters and the HR professionals, because I am in this field for the last 35 years. I have seen the industry, I have seen the courts, I have seen practicing in the courts, how practical, there are so many myths. What they think is that here, once the case is over, they feel that they have accomplished it, but I tell you, it is not an accomplishment, it is finishing. There is a difference between completion and accomplishment. You finished your job of disciplinary action. You finished your job of finalization of recruitment. You finished your job of conclusion of contract. You finished your job of executing the bond and so on and so forth. Where there is a violation, where there is a breach, then you will have to go to the court. Then go to the court, you have to question yourself, where do we stand if we go before the court? But normally, mechanically, so many things nowadays, what is happening is that if somebody joins in the profession, they don't try to introduce their ism. They will be following whatever is there earlier. At certain times, if it is a manufacturing industry, if you are joining, if you are asked to draft an agreement, you look for a similar manufacturing industry for similar position, what was the draft, and you put it in the WhatsApp, because the technology has come nowadays. In good old days, that was not there. And you ask, can you throw some light or share some document? The document is shared, and you would be copying it and pasting it and executing it. It is a cut-paste technology. Telugulo aithe ఎత్తిపోతల పథకం. But I came across a case where some gentleman came to me for the certification of standing orders, and he got to submit the draft standing orders. Many of you who is in the manufacturing sector are very well aware of the standing orders, its impact and other things. Not so for the IT, ITES and service sector. For them also, under the new labor code, it is being applicable. Even in Bangalore, Karnataka, the standing orders are applicable for the IT, ITES industries, where there will be certain do's and do nots are there. But when it comes to, one gentleman did come to me, I am just thinking that it is an experience, treat it as a case study or whatever it is. One gentleman came, sir, I drafted my standing order, sir, that you only have to do the wetting. I thought I can sprinkle the water, there ends the matter. But when I went through the draft, there are certain clauses they have put it and typed as it is deleted. I said the other clauses are okay, what is deleted? Because he copied from the other standing orders, where after certification that is deleted is also copied. So even copying should be art. We should use our mind. We should not do it mechanically. It has to be done intelligently. Even copying, nothing wrong in copying anybody because nobody is the master. Everybody learns in the process. In the process of learning, you should have to put a bit of industry so that you would be able to appreciate what you copied. Otherwise, you would not be knowing. So even in these employment contracts, I say, for example, selection to separation, recruitment to retrenchment. You will be having several contracts right from offer, appointment letter. Again, this differs from industry to industry. In the manufacturing sector, they go directly, they call it as an appointment letter. In the service sector, they call it as an offer letter. Offer is appointment, appointment is offer. There is no change in it. And in the service sector, they will be putting class 1, class 2, class manufacturing, class 3, so on and so forth. Here, the offer would be the precise, and there will be annexes, article 1, article 2, article 3, article 4. But the essence is the sense, and the sense is the same. But what is the thing? Many of you may not be knowing what is the difference between an offer and appointment. And many IT companies nowadays, at times they have the recession, they have the problem of layoff, at times they need the manpower, they got the problem of talent acquisition because attrition is there. To arrest the attrition, they got to replace. And then the other thing is that, like Wordsworth said, men may come and men may go, but I go on forever. Organization has to go on forever, irrespective of the people do join and leave. At times they say that he has joined. Some candidates, they took offer letter. Even before they joining, when you are expecting for the day he got to join, he will send a regret letter. Quite often somebody's sickness, quite often some problems which cannot be disclosed or what you don't know. But you would get a regret letter, and for you to replace the talent, it will take pretty another 3 months because you got to select, and he has to give his pretty notice to the current employer. And even if you are willing to buy the notice, he may not be prepared, they may not be willing to relieve him. And ultimately, both of you compromise and join, take a person without relieving letter. Because it is not principle based, it is the need based. Am I right? And you yourself complain against each other saying that people recruiting that manner is unethical. But who is at fault? I say workmen and employees are organized. Employers are the most unorganized. What the right hand does, left hand doesn't know. You don't know each other's practice. You don't know who joined. So they say that suddenly after the problem comes, this fellow I am expecting and I am ready with the garland. But he landed in Ireland. With my clear eyesight, I am looking for him. He went on site. So these are the problems normally. How foolproof is your offer? You got to question yourself. When you give the offer, what you say is simply offer and appointment letter, all the terms and conditions you put it. Especially the IT sector is facing many challenges. Now virtual has come. That virtual, I don't know, virtual is also become a simple ritual. There is an impersonation. And you use so many technologies, artificial intelligence and machine learning, and human intelligence is above all intelligence. A delinquent brain works better than an enforcement authority's brain. Do you know that when Rajiv Gandhi was assassinated, the people who killed Rajiv Gandhi, the mode of commuting? Do you remember? Or many of you might not have born at that time, or born and forgotten? Not your birth, I mean the incident. Okay? Yes, the enforcement was searching each and every vehicle. But these people commuted in a water tanker. Can anybody imagine a human being commuting in the water tanker? So his brain worked beyond the enforcement authority. They safely reached to Bangalore and everybody is searching. So our organizations also would be at times, I can't say all, few which came to my notice from out of my practice when I go through are the same situation. So our problems are our guiding points, our lessons. We have to find solutions and move ahead. When the problem comes, we forget about the problem over a period of time, we re-invite the problem. Over a period of time, we get habituated to the problem. If you are not having a problem, that would be a problem. But I am putting it on the serious note, though it looks like a Nityananda's lecture. Some rhythmic, with some rhymes and, right? That's what one got to know. In the offer letter, what one got to put it is that offer is a provisional appointment. It is not a final appointment. Prima facie, you have seen him and you feel that he suits your requirement. When he suits your requirement, normally you say that you are provisionally selected and your compensation package would be so on and so forth, something like that you say, and you'll have to say that you have to communicate your acceptance in writing if the offer is willing within 1 week or 3 days from the date of receipt of this letter, and once in the event also you have to communicate your date of joining and confirm. Once if you communicate your acceptance and date of joining, if you don't join, you end up in payment of liquidated damages. Are you able to follow me, or am I a bit fast like Shatabdi and Rajdhani? Huh? Otherwise, I would be completing but not be accomplishing it. If you got it, I would be accomplishing it, right? So you must put some clauses like that where you are not giving the responsibility, you also give the accountability. Where the accountability and responsibility go together, then it works out. I see I address n number of sessions for many of the IT, ITS, even in SHRM I did address sessions. But normally, mostly IT people are under the myth that the labor laws are not applicable to them. Once I asked in one of the sessions where nearly 120 IT HR professionals attended in a SHRM session long about a decade back, I did ask them, some of them, that do you have workers? 98% raised their hands that they don't have workers. But 80% of the staff are workers. Then I asked them, how are you saying that you don't have workers? They say that we are all having white collar employees just because they are wearing white shirt. This white collar, blue collar, black collar and green collar labor, you know who they are? Hospital is not green color, sir. It is an agricultural labor is green color. Black collar is not lawyer because a lawyer wears a black coat. They are the criminals. Because when they are identified with the color is the problem. We have to identify the employment by nature of their employment and occupation, not from our perception. That is what the law teaches us. That is what the interpretation of statutes. That is what the General Clauses Act, where you have a doubt on a particular subject or a particular provision, where a word, suppose if it is not properly defined, how it is to be defined and has to be learned from the General Clauses Act. So, in the law, there is no such definition of blue collar, white collar, black collar. It only says workmen and non-workmen. Workmen and the supervisory and managerial. Whoever is not discharging the supervisory and managerial functions, they are the workmen. So all these people think that because everybody is coming shoe, tie, tuck and other things, of course, once in a while they will be having formals, t-shirts, jeans and other things. That's a different issue. But they'll feel that they're all employees. But in good old days, in the early 2000s when IT started, if I remember rightly, there were no disputes. And the government also encouraged them with certain sort of exceptions. That exceptions are not permanent, it is being extended from time to time, once in 5 years, once in 3 years, once in 2 years, something like that. Many of them do not aware that there is an exception, there is a labor law, because there was no dispute. Necessity is the mother of invention. And somebody did ask why the government is giving exception from time to time and subsequently withdrawing it. Because initially to lure the industry, they offer this thing. Afterwards, when the industry is set up, where do they go? Like Brahmanandam joke, first she loved me, afterwards I have no other option but to love her. You love the state, but by virtue of the incentives, afterwards you have no other option but to love the state. But the state loves you. So you have to be prepared for the challenges that come in. And many of you do not know that there was an exception earlier, there was an exemption from applicability of section 47 when an employee in the IT sector has been dismissed. He can't go before the labor officer under the Shops and Establishment Act. He only has to raise an industrial dispute before the labor court. In the recent about couple of years back where that cleverly they deleted. And no IT industry did notice it. That's not a good sign. Adjudication by a district judge is different from that of a adjudication of your termination matter by a assistant commissioner of labor. Another thing is that in a manufacturing industry, the blue collar employees whom you call so sweetly in a management term blue collar, but who are the workmen, their salaries are quite low than the salaries of these who come under the definition of workmen under IT. Your engineers are being paid 15 lakhs per annum minimum. And you are not getting talent, even after offering 15 lakhs real worth. And often you compromise. So what is happening is, suppose in the event if your termination is wrong, if he has been reinstated with back wages, as I told you, litigation is a speculation without knowing the destination. Okay, right. Because we need to have tons of correlative evidence is equivalent to ounce of documentary evidence. I'll have a documentary evidence that I did attend the session. Just in the lighter vein you take it, right? Pardon? Yeah. Then we will do, yes, we will complete it now. Yes, because it will be on and on, and only I will be doing justice to the IT. Let the other wings are also there, right? You can be the moderator, I would answer, right? That would be good. You can be seated here. Yeah.
So actually we have made the new sectors and we have collected these questions.
So that if we clarify their doubts, they will be having a takeaway. Otherwise, as long as I am saying something, their doubt still in mind.
And if there are any questions, we will be skipping.
No issue.
So the first question, overtime, irrespective of gender. The question is, people are having to work more than the physical requirement. Every industry faces the same problem. What should be done?
Here the problem is that most of the employees and most of the companies, most of the HR managers, most of the employers under the myth that overtime to be paid on basic and DA. Do you agree? Because I said myth, you are not agreeing, right? Otherwise, what do you follow? Do you follow that the basic and DA, mostly manufacturing sectors, even IT is having overtime, but they will be giving comp ups, right? They don't call the overtime, but they're also in the call centers and all, they started claiming overtime now, right? Yes, sir. No answer from you, you'd be paying it on the basic and DA or on the gross? Yeah, gross is right, but most of the companies are paying on basic and DA, that is wrong.
Let's say a continuation question. If an employee is working on weekly off, and also it's a declared holiday, so how the OT calculation to be made?
No, any day if either there is no concept of 3 payments, because one for the weekly off, one for the declared holiday, August 15th fortunately or unfortunately happens to be that weekly off. because some people do get the rotated weekly off, staggered weekly off rather. If that is the thing, he has to get one payment for the weekly off, one payment for the holiday, and two payments for working on that day. Totally he end up in 4 payments. He need not work for rest of the week. Right? Yes, it can be compensated. He can declare the whole factory as a holiday on as a working day on a holiday by giving the compensatory holiday, compensatory working day. You can ask them to come. But that is a time limit as per the statute. It has to be within the period of 10 days, I think so. That has to be done, not at our own sweet time. Of course, if we all, management and the union agrees, it can be any day, because Miya Bibi Raju hua to beech mein kya karega kaji. Right? Yes, ma'am?
Is there any equal remuneration act? How to manage the compensation? So 50% of basic pay, how to address?
Yeah, I got it. It is all about the Equal Remuneration Act, where any employee claiming that we are doing the similar work, we need to be paid the equal wages on par with the other person, whereas I am being paid less, he is being paid more. The comparison and the anomalies would always be there. But Equal Remuneration Act has came into effect, but it has not, implementation has been not been notified. Because it has been not notified, authorities has not notified, it is not being, but as per the constitution, where a similar work is being done, even under the Contract Labour Regulation and Abolition Act, as per the rules, there is a provision that where they are doing similar work to that of the permanent workers or to some of the similar work, they need to be paid on par with those employees. But again, that is $1 million question. Is it by virtue of the seniority? Is it by virtue of the work they are doing similar work? And by virtue, again, their skill? What is? But they will be having a different skill. All has to be weighed and it has to be viewed from case to case, but it cannot be generalized. But claiming equal wages is a right. And now, under the new code, which is always in the loop line, and we don't know when it will come into the pipeline, and until such a time that is covered, right? Okay. Yeah, as per as the gender, there is no gender difference, because in the villages for the women coolie this much and men coolie this much, under the labor laws there is no such differentiation. All has to be paid equally. Men and women are equal. There should not be any gender bias. Earlier, women are protected from the night shift. Now they said that when they are equal in everything, why can't they be prevented from working night? They also extended the night working for them, right, sir? Yes.
That's the question.
This is a rapid fire.
Is there any special provision for female workers during night shift in the current?
There is no special provision, but however, the government has framed certain regulations and rules for them that they need to be dropped, and the female employee has to be dropped first and the male employee has to be dropped last. There should be a security guard. The car numbers of the drivers has to be noted. All these things, precautions has to be, they should be picked up if it is beyond 10 o'clock right from the residence, and they should not have any problem. But in recently one of the IT industry, they did complain me, that is one of my client companies, when the cab drivers are given with the numbers of these women employees, and they are downloading the profile pickup from the WhatsApp and they are making some sort of nuisance. How to prevent them, right? That we will deal it afterwards, right? Because we will go ahead with the questions. Prayer consent for downloading the I'm just putting it in the lighter vein, okay? Because it is post-lunch session, no? Every time I'll have to keep them awake constantly. Otherwise, they tend to slightly nap. Right.
So how the outcome is defined under labor code?
New labor code, there is no change, but the number of hours will be there, that 50 to some 75 hours for this thing, that should not cross. In most of the manufacturing industries or wherever it is, they keep these watch and ward and as well as security personnel, and security personnel, they put the limited guards and the contractor takes money and goes away, and these people will be working in a quarter and more than 200 to 250 hours also, because if the reliever doesn't turn up, they continue. And ultimately there would be a planned absenteeism. They collude with each other and say, you don't come, so that I will continue. I have some work next day. And thereafterwards, in one company, it so happened they have been doing so that ultimately the inspector of practice somewhere to catch where he could not get something, he caught this security personnel, and ultimately the wages is the liability, vicarious liability of the principal employer jointly and severally liable. He made a huge millions of claim. And we can't say that, and the contractors keep changing, he would be going away and this person would be continuing. Like I said, men may come and men may go, but I go on forever. Only the name lending contractor will be there, there will be the change of the name, you would be working that all 20 years with you. And the security guards may be seniors to most of you who is still working as a contract labor. That is the scenario. Yes, sir. It is definitely illegal as on today, and the new code we don't know. It is only the loop line and not in the pipeline. And we don't think it would see the light of the day before the next general election, because general elections are hardly about an year and a half round the corner, and nobody is touching it, right? So it is clearly, glaringly illegal, right?
How far we can engage contract laborers, and what is the perennial nature of law?
A contract laborer are permitted to be engaged only in the intermittent nature of job, not in the perennial nature of job. But it is very $1,000,000 question to explain. Normally they have enumerated what are the operations that come under the intermittent nature in an amendment, I think, to section 2, subsection D of the Contract Labor Regulation and Abolition Act, watch and ward staff, security staff, so on and so forth. And even the manufacturing sector or any person are permitted to engage the contract labor even on a perennial nature of job or operations to meet the sudden exigencies in the workload. Could you get it? But that should not be forever. The sudden should not be forever. Like you say, no, purely temporary, likely to be continued. That sentence should not be. Because judges are clever enough to know, no, they read in between lines. However you put it. So it should not be purely temporary, likely to be. In good old days, there used to be appointment letters for the NMRs, non-master role employees, purely temporary, likely to be continued. Right.
What is the definition of wages? Is it gross salary, basic salary, or CTC?
Entire component is the wages. You call it whatever name, whatever nomenclature you use it. You call it as an allowance, you can. But wage definition differs from one act to the other act. When it comes to the gratuity, it's basic plus DA. When it comes to the overtime, it is the gross wages that is to be paid. When it comes to the leave encashment, it is again the gross wages that is to be paid. So it differs from act to act. When it comes to the ESA, except barring one or two allowances like washing allowances and all, that is a gross wage. When it comes to the PF, it is basic and DA. So wage differs from act to act. We can't say this is what. It is, I can say, like an amoeba. The definition is same, sir. Definition only says, the only thing is that they will say that because sometimes people are at loss to understand whether the bogies are pulling the engine or engine is pulling the bogie. They will put basic 10% and 90% allowances. To avoid that ambiguity, what they are doing is gross salary is divided by, that is 50% of the gross salary is allowances and 50% would be the basic PF contributory or gratuity contributory fund, so that you can't escape it. But for every law there is a flaw, there can't be law without flaw. We still, people do search for it. That is a different issue. But let us see when it comes to, and it is that is only the main difference. And even papers also, so many articles have been saying day in and day out about that employer's cost is going to be increased, take home pay is going to be reduced. And there is a lot of debate and WhatsApp discussion. Somebody puts the point, somebody throws the light, somebody throws the stone. Light in the sense right meaning, stone in the sense wrong meaning, on the notions. And if it is a suggestion is on the provision of law, it is a light. If it is on the notions, it is a stone. Right, sir.
Continuing that basic, 50% basic, 50% of basic, how to address new labor costs, how to balance financial impact of basic policies within that 50% basic and the other benefits.
Yes, sir. Normally the thing is that everyone comes and they introduce this thing. But law mostly deals with basic wage, deals with dearness allowance, deals with law, neither the provisions of Payment of Wages Act or any of the acts doesn't say washing allowance, car allowance, driver allowance. HRA under minimum wage, they dealt with it. So many allowances are invented. I don't know, because certain people say to put those allowances to save PF, certain save ESI, certain to save gratuity. Now, to avoid that, the new code 50% said everything. And certain people say CTC. CTC, they put the gratuity. GTC, they put the statutory bonus. That also question is there. I'm just covering it. You can skip it. And that gratuity, they also put it the basic bonus. Bonus is a contingent one. Because bonus is declared after finalization of accounts, you have pretty 8 months time to close your balance sheet and arrive at your set on, set off, allocable surplus and then compute what would be the bonus. But you can't predetermine the day employee joins, this is the bonus. That can be the 8.33%, can be 10 to 20% based on the allocable surplus that is available. But you put it on the bonus. Then you say that performance bonus, that is statutory bonus. Somebody is silent, they will say it is bonus. What? And that becomes a bonus for them. And bonus lies on you to prove what bonus it is. You got to be careful. You know what is bonus? Right. So, this is all problem arises in this cut-paste technology. Ethipotal Padakamlo. Pardon? Gratuity is a contingent payment as of today, and the new code, if it comes, if he is appointed, again there is a myth. Gratuity, people do ask me, even by putting 1 year, we have to pay gratuity. No, it is only for the employees who are taken on a fixed term, they need to be paid gratuity for that term. If he is employed on a permanent roles, he would be entitled for the gratuity only upon completion of 5 years of service. That is under the new code also. In the present code, when you are putting in the CTC the gratuity, you have to pay the gratuity even if he doesn't complete 5 years, because you have lured him that this is his wage. His contract confers him right, not the act. So that is again bonus for him. Yes, that is enough. 4 years, 240 days, that is enough for them, because that continuous service is defined as 240 days. Once if they cross the magic figure, they are entitled. That's what I said. Basically, you have to be being human is more important than to be the human being. And 3 month service left is only a slip between cup and lip. The gap is very limited. Why to spoil our shirt unnecessarily? Let us have the slip. If it falls on our shirt, it would be unnecessarily spoiling. Here the shirt is the organization, the reputation of the organization. Gratuity is the amount being paid to an employee towards gratitude. 3 months falling short, gratitude come hota hai kya? What about the gratitude of 4 years, 8 months? Right.
Yeah, related to ESI and PF, NIM and NAPS under the ESI and PF.
Yes, they are. Yeah, I know that. This All India Technical AITE, that is the thing, scheme that is brought by NIM. Okay, National Employability Scheme, and that is the thing. And they wrote it, and the PF and ESI department hasn't yet given so far, I think, to my knowledge, the clarity about it. And certain of the places, the PF department, because what they have exempted is the trainee. Trainee as defined under the standing orders. But it is a good question. A trainee in the sense, here it is very important, please make note of it. I have recently given my legal opinion to one of the industries, my client companies. The PF department interpretation is trainee means trainee. And he is working on a mission. How can you call trainee? He is an employee, but you are using his service as a trainee. And if we go on giving the lecture and confine to ourselves in the theory, there is no difference between that ITI institute and our company. Training is on the job training. So he would be learning the things only by way of practically working, irrespective of the thing by what he gives. So training includes practical on the job training where he is working. By working he would give some output also. It is not the trial run, because who will bear the raw material cost for the trial run? So you see, there is a movie, no? You say, what is he doing? He is loving. What are you doing? I am feeling the love. Working on the job, gaining on the job experience, feeling the experience, not loving the experience. So there is a thin interpretation. Now they are also pursuing it. PF department also considering for exemption of these people from the ESA and PF coverage. But ESA always better to cover it in the manufacturing sector, because if they met with an accident and all, that would be a risky factor.
Okay. Non-ESA context, is health insurance
But
is health insurance?
health insurance is not anything mandatory, only when it is statutory. For the employees who are covered under ESA scheme, that is taken care of. Who are excluded from the definition of ESA and not covered, insurance is not mandatory. Normally, by virtue of the union settlements, they enter into a settlement, and that becomes a right, and that because any privilege given over a period of time becomes right. Pardon? Service sectors, you are giving it a generosity as part of CTC, and if it is not part of the contract, if it is not part of the contract, you need not, you are not legally obliged. No, when you are not legally obliged, it is not mandatory. It is purely at free will.
There are questions received from those who are attending online. So I will be clubbing these two questions.
Yes.
What are the consequences to be faced by the candidate who has accepted the offer but not joined?
That's what I initially covered it in my lecture, that they have to take care in the terms and conditions of the offer letter that if they don't turn up on the D and join, they end up in payment of compensation. That has to be mentioned there. They will be paying the liquidated damages on the D day when they fail to join.
The second question related to that, what are the consequences to be faced by the employer that offer issued to candidate but not allowed the candidate to join for whatsoever reasons? It could be recession,
Even otherwise also, there is one person in one of the companies, he was given a hotel accommodation for joining. First day in IT company, first day he worked well, second day late night he came because that 1 week accommodation, he was fully drunk and fought with the receptionist. Then it was brought to the notice of the employer said goodbye. And he said, I got an offer, I left my employment, came here, and it was only out of temperament, I just scolded her, it is nothing. But that is not part of the book. Immediately, he just entry and exit is the same day. That can be done. Not an issue at all, because you can't be, at least you are, before he could join your company, you came to know the true color.
What are the provisions for full-time employee and full-time contract with the current legislations and upcoming legislation? External employment.
The word itself is fixed term. Thereby the term is fixed in the word itself. Am I right? Like we call danger apayam paper item. So what I mean to say is, yes, in the present law also under section 200BB of the Industrial Dispute Act, any termination upon expiry of the term contract doesn't amount to retrenchment. If you employ any person for a particular period, be it 1 year or 2 years, even under the present law, because it nowadays talked much about it, in the new code it is going to come, present code it is not there, it is there, it is going to be there even in the new code comes, that would be a new wine in the old wine in the new bottle, and he is employed for a particular period of 1 year, and you have to be clear in the appointment letter terms and conditions that your employment commences on such and such date, and you cease to be employed by completion of the period automatically without any further notice or termination, and such a termination upon expiry of the contract doesn't amount to retrenchment as per the provisions of the ID Act. You are not entitled for any other benefits, and you also have to say that this is only to meet the requirement and it will not confer any right over you to claim regularization or a confirmation after completion of it has to be. I can say in nutshell, but it is voluminous. I have put it luminously. Right.
Question is, in an emergency, can we deploy semi-skilled or unskilled laborers in a core?
Core is the skill itself is the core. You will not
They are semi-skilled or unskilled.
semi-skilled if you put it to the core employment, it is the skill is being elevated. There is no problem. You are upgrading the skill, but you also have to pay the wages, not the semi-skilled wages. Yes, what Mr. Dakshinamurthy said is right, and that is as per the minimum wages GO. They have put unskilled is also what they have said is they have measured the skill by number of years, but not by the nature of work, which is glaringly wrong. But if they have put in 1 or 2 years of service, something like that, even the helper is now is a semi-skilled. Am I right, and Dakshinamurthy garu? Unskilled is also yes. That is there.
Is the medical employment or the fitness for the employment is mandatory?
Yes, sir. Because he should be fit physically, then only he can fit into the organization. If he himself doesn't fit, he can't fit into the organization. Organization will become sick. And you have every right to undergo him for the medical examination before he joins.
Mandate of fresh facility, both in service.
Yeah, it is mandatory, and some people are outsourcing it for 4 or 5 establishments together. Somewhere it is they are putting it. It is not entirely in fact. Otherwise, you will have to leave the mother for the breastfeeding in between, and they will be taking time. You should not complain. 3 man-hours are lost. Huh? That is it. The Act did not specifically decide. There may be Kunwara Babs also. How do you know? You know, some Hindi movie came, Peligani Tandri, something like that. There may be. It is basically a child care. But Act specifically didn't say only where the women 50 employees they said, but it is man. Nam? Pardon? Because they have the vision to avoid confusion. Because they are visionaries. We are all listenaries. Right.
Yeah, employment termination by employee, a mandatory time frame, 15 days. Is it any specific term?
I couldn't get it.
Like termination of employment by employee.
Okay, right. Many IT companies do put that if you got the employee got to leave it, you have to leave, give 3 months notice, or if you want to terminate, you are required to give 3 months notice, or in certain of the companies it is a couple of months, in certain of the companies 1 month, in certain of the employers say when I want to send him, I will give 1 month notice. If he wants to leave me, he got to give me 3 months notice. We should not be fair and logical. It should be equal on both. It should be mutual and reciprocal. It should not be unilateral. Any unilateral agreement cannot be enforced. It is a negative covenant, but not a covenant that can be enforced. Because the Supreme Court already said in one of the cases, the contract between employer and employee is a contract between lion and lamb. There may not be free consent. So it should be the equal. You have every right as per the contract of service. But one thing you got to keep in mind, in the recent past, I came across a case of one of the IT companies again, and that particular employee comes under the definition of workman, because in the IT company only team lead onwards, who head the project, who guide the people, a team of people and other things, investment supervise, they are excluded. Normally other persons whom you call it as whatever designation, executive, general manager, vice president, as long as he doesn't have powers of supervisory and managerial, he is still a worker irrespective of the designation or the salary what he draws. It is a case where it came to my notice, he got to give 3 months notice and serve it or pay in lieu of notice. In certain of the company, I don't want to pay, he has to work. Even if you want to send him, you have to put it like that only. It should not differ from one side to the other side, it should be mutual and reciprocal. So the employee left and ultimately went to the Labour Department, and the Joint Commission of Labour as usual called for a joint meeting. There he said our contract. But the managerial and supervisory employees are governed under the service contracts as per the terms and conditions which you agree in your appointment letters, agreements, contracts and bonds. When it comes to the workmen, they are governed under the law, Shops and Establishment Act, Industrial Dispute Act. Law supersedes your contract doesn't supersede the law. That is the bottom line you have to keep in mind. Another thing what he said is that what the law prescribes is 15 days notice, Shops Act. Then he say you might have put 3 months or 1 year, but it should not supersede the law. He can go. But how many of you know, you don't know? So whatever you put it, that is on the paper. As long as employee doesn't know, of course you yourself may share with your colleagues and you may avail it. Tomorrow we don't. It spreads like a grapevine talk, right? Yes. మ్యానుఫ్యాక్చరింగ్ లో కూడా వచ్చేసి 1 month నోటీస్ ఆర్ పే ఇన్ లీవ్ ఆఫ్ నోటీస్ అని చెప్పేసి ఐటీ యాక్ట్ లో ఉండింది. దట్ ఈస్ రిట్రెంచ్మెంట్. అండ్ ఇఫ్ ఇట్ ఈస్ బిలో 100 నో నీడ్. ఇఫ్ యు ఆర్ 100 and above, in the AP it is 300 and above, in the Telangana it is 100 and above, you need to take permission for retrenchment. There is a long process. You can't say kal se naya aane ka, because he will come day after tomorrow if you say like that. He will not come tomorrow, but come day after tomorrow. If he doesn't come, court will send him. Right.
The resignation of employee post-utilization of maternity leave.
Yeah, because they got the benefit and they are giving us a national party emblem. Pardon?
Yeah. Maternity leave, the profit resignation impact.
No, what you mean to say is that an employee went on a maternity leave. After availing the maternity leave, instead of coming back and working as a gratitude for giving the maternity leave, she resigned. What to do? Pardon? That is the question. All right. You are not audible, sir. After availing the maternity leave, somebody come back, somebody says that the doctor advised me for 6 more months leave, you give me, where you can't give me, you relieve me. That is one case. The other case is that I am tendering resignation, I am moving to the other place and I cannot come. Third thing is that the child needs my care some more and I will not be able to come, and you grant me 3 more weeks and 3 more months, then I will come you back. Either it is with pay or without pay, no problem. But for you, the work suffers. In that case, can you terminate? Is it the question? Or you may even go to the extent of, can you recover that maternity leave benefit? No, that is not possible. Let us say, frankly say, because why? Because we always think ahead. That is where we think ahead. And you can't take a bond from the employee before availing the maternity leave is her right. You are not extending a courtesy. It is the right conferred under the statute. You can't say that after completion of your maternity leave, like you are sending an employee on-site training and after coming back he got to work for 2 years, you can't. And for the service what he had put in minimum 6 months, I think, if I remember rightly, then only they are entitled for the maternity leave. So their eligibility criteria is fixed prior to availing the leave. Not they did not put any eligibility criteria post leave, that they got to work, then only they will be. But it is might be beyond the vision of the legislators. Right.
This during maternity.
And I'll tell you an example how why I said the employer is just a couple of minutes for you people to be got alert. And there are so many employers organizations, so many mighty people, so many business people, quite influential and all. I had an occasion to address a session in the Mysore Chamber of Commerce, Federation of Chamber of Commerce, where my co-speaker was one of the author to this labor codes, the regional central labor commissioner. Then I asked him simply one question, that in the new code, in the present labor laws, if the employee wants to prosecute the employer, he has to give a notice, he has to make an application to the labor department, and only the labor department got right to prosecute the employer. Under the new code, employee is directly conferred with the power of prosecution. He can directly prosecute the employer. When it comes to the employer, if he wants to prosecute, he has to approach the labor department. And this many must be CII, PICI, whatever. You know better than what are all the organizations. Nobody raised a single point. Then I did ask him, that one of the others, sir, how can it be? It is not fair. When they were given, why you have not given to the employers also? Then said, no employer organization asked. Whereas the trade unions did ask, because we make an application, we don't act upon, and the government doesn't have machinery to act upon. It is better to they do. Better to give it to them. They will fight among themselves. We will be the spectators, so that they can be dictators. Pardon? It is not, that is a different thing under idea. I am saying if you were to pay the wages by the day, if it is not paid on the 7th or 10th, 11th he can send you a prosecution notice. Even if you pay on 12th, you have committed an offence. An offence committed is an offence even if you rectify it. At the most, court at its discretion may compound, may not compound. Once committed means committed. And under the new code, they said that within 3 days from the date of relieving, you got to settle his full and final settlement. You can't go the sweet correspondence. And on 4th day, he can prosecute. Whom he can prosecute? Not the manager, immediate manager, or reporting manager. He would be the director on the board. Because whoever is nominated as an occupier under the Factories Act, he should be the person responsible for prosecution. Right? Yes, ma'am.
One question. During maternity, women are eligible for gratuity bonus.
Yeah, when it is a leave with pay, when it is leave with pay, it is treated as continuity of service. Suppose again there may be another question. She had put in for 4 years, 5 months service, 6 months is the maternity leave. Is she entitled? Yet she is entitled.
In the new wages, issue of full and final settlement and the time limit for payment.
That's what I answered earlier. That is prepaid, not postpaid. Pardon? No, discontinuation by the employee, asking the employer to discontinue. The employer asking the employee to discontinue is a termination. If the loss of pay, if he doesn't have leave to the credit of his account, then he can put on loss of pay if you wish. If you feel that you can terminate his service, because it is unauthorized absence. Yeah, for gratuity, the physical working days that is taken. ఏదండి? He needs clarity and query.
It could be unauthorized or it could be loss of pay as part of the disciplinary litigation.
So the loss of pay
Doesn't have leave, but it goes on the loss of pay. Can the HR has the privilege of saying who don't have continuity of service? For example, if he is a disciplined employee and has a couple of loss of pays and he claims for gratuity of 4 years, 8 months or 4 years, 240 days. Can that be said? You don't have continuity.
So the continuity of service has to be looked into each year. Suppose out of 4 years, if he is following some sort of continuity of service in 2 years, he is not entitled for the 2 years, for the rest 3 years, he is still entitled. We can't say that you are not totally entitled.
Wherever this continues,
He is there, he has to be paid for that respective years.
I think this is not followed majorly. Then you can bring discipline among the employees, avoiding the loss of pay,
Sure.
because they need to inform the employer well in advance that they will not be able to come, so that manpower adjustments can be done in the companies. Today, loss of pays have become the national norm. So how do you control that? When there is a provision that wherever there is continuity of service, for example, the first 80 days is required, continuous 80 days is required to enjoy the maternity benefit. Within 80 days, if the person goes on the loss of pay for 1 day, then automatically the continuity of service doesn't come. And from that particular day, again 80 days continuity of service has to be treated for maternity.
No, it has to be looked into overall year, but not, you can't count every 80 days.
You would say for whole year that you don't have, for example, January the person joined.
I'll tell you, for example, it's a case, take a case that where he joined in January, put in 75 days, 5 days he did not, and after 5 days of absenteeism, again he comes and attends another 10 days, it has to be looked into whole, you can't split it and look into.
With the same
Just preceding her maternity date of leave, whether it is break or without break, if she had put in that 80 days has to be considered.
There is one more incident which we are seeing in the recent past. If the maternity leave, as per the law, they have to start, say for example, in December. 2 months, 3 months prior to that, they are applying for some sick leave, some loss of pay, and they are taking, and from there.
No.
That's example, this order. These 3 months, can you deny that loss of pay?
No, what is the legal right? It is her right. That's what, before, I am not talking that, saying that before maternity she got a legal right. What is the legal right? Legal right. You can't deprive the legal right. Beyond legal right, whatever is to be given, discretion of the employer. Before commencement of the maternity period, if she got any leave, you have to give it. If she doesn't have leave, you can make loss of pay. Whether you don't want to make loss of pay, you can terminate also. But not during the maternity period. If you terminate it, you are liable for prosecution. It causes lot of mental agony to the woman employee.
What is this? She is on the family leave already, but it is not intimated to the HR. The intimation is not only the 6 months.
When she is naturally, when she is eligible for, why is the necessity for the employer to intimate immediately the moment she is conceived?
Not required. So if both working they go on sick leave, can it be denied?
It is up to you. If she got if the medical emergency commands, you have to be. If the medical emergency doesn't command, still if medical emergency commands, and if you still reject it, it is for the court to decide whether the leave sought is justified or unjustified, and then it is to be given or not.
What is your suggestion?
My suggestion is always be practical, don't be hypothetical.
This is from service sector. Employee customer.
Employer,
Customer.
this background check and all is not properly done. Employee is cheating or employer cheating? Employer is cheating customer. In what way it comes under labor law? It comes under consumer.
The employee who is working in that organization, how far employee is responsible on.
I got you. What you mean to say is that when the employer cheats the customer and the customer has been dealt by the employee, where the employee got no role and he has to act to the terms and conditions of the employer. In the process, the end loser is the customer. Am I right, Pawan? Huh? Right. Huh? I'll get your point. It is a case where you have a marketing employee, without his authorization, beyond his powers, he promised certain commission to the employee to push the sales. He does it and he leaves for better prospects. Thereafterwards, this agent calls that he promised me the things and therefore I will pay you only this much amount because I am entitled for that. He has done his job, he completed. But in his KRA, he feels that he accomplished it. You also reward him. And after he leaves, the problem would crop up. Then he comes, he promised. Then you got to tell, first you must have a guidelines. Recently I came across such a query from one of my clients that this is the thing that happened. It is a multinational company. He promised whatever is possible below the sky, on the earth, over the earth, and he promised and he left away and he performed as the best employee. Best employee award was also given to him. And afterwards, one after the other cases, when they went for the recovery, they say, these are the things that they are coming across. Then we said he is personally liable and responsible because he is not conferred with the power. Nor you must have a dealership agreement. In the dealership agreement, you must have a clause that any discounts or any such thing is only should be given by the authorized persons as a company policy. Anything given in personal capacity is not binding on the company. You must also have. There should not be any ambiguity. If you are unambiguous, your liability is clear. If you are ambiguous, your liability is also ambiguous. So that is why you have to customize the document from time to time, incorporating this sort of experience to overcome and to circumvent it. Otherwise, you continue to have it. Otherwise, then they don't have point, they adamantly argue. How can it be binding? The adamancy will not enforce the law. Yes, is it clear? Even after post-retirement also, you can still say, you can prosecute him, or that dealer can prosecute him. He has been induced to purchase the product by offering the commission which he is not entitled to. Anything inducing and making the other person to believe is the definition of cheating. Where there is a will, there is a way. Besides the will, they should also have the courage. Besides the courage, they should have a patience for fighting the litigation, because it is a speculation without knowing the destination. Yes, sir. I think all of you might have exhausted, looks tired, and wants to retire for the day. Huh? Okay, not from the service, from the day I said. Or ultimately, after relating to this, these are all so many problems, better to retire from service to me. No, don't tell. Right.
Employer liability and the migrant workers.
Yes, many of you know what is migrant workers? Who is migrant? Whoever is suffering from migraine is migrant? No? Right. Yeah. So you got to register under the Interstate Migrant Workers Act, and under the Interstate Migrant Workers Act, the worker can sue you from his native place. Place of work is not the criteria for jurisdiction. His place of residence is the criteria for jurisdiction. He can sue you from there. That is also a problem. Yes, sir. They also do come from Bangalore, Bombay, and it is a pan-India, and also they ran India, and whoever comes under the definition of Acumen, even under the IT, because IT is also not exempted under law, they can as well pretty well file it. But we say that as per the employment contract, any litigation is subject to the jurisdiction of the Hyderabad courts alone. They must have come. But this, as I said, the statute supersedes the contract. Contract doesn't supersede the statute. Because the dog can wag the tail, but the tail can't. No, they can file it from there, provided they have to prosecute you under your local laws, not the local laws over there. Besides the local laws, there will be central laws. No, but the governing law is the place where he works. Suing place can be at his native place. Any immigrant, because the act there is no exemption where they are living border. No, where there is no, Where there is no order for the border, you have to follow it. Whether they come on their own or you bring them or lure them or whatever it is a fact they worked with you, they are working, they belong to some other state. Or else what you got to ask him is that create themselves a voter ID card over here and the Aadhaar card over here, they should transfer the Aadhaar card over here, then ensure it and then come. Even for opening the bank account, the employees don't give it, forget about that. Even for the PF UAN number for creation, you are not getting the Aadhaar, you are becoming Aadhaarless. But by the same time, employer says, I need manpower. And you have to exercise your power and take it. Right, sir.
Now, next question is registration for the unions without verification. And followed by the question of, can trade unions interfere in the issues of contract labor?
Yes. The thing is that the trade union, it must have a registration. For registration, normally verification. Verification means that the 7 members who subscribe for registration of the union must be the employees on rolls. It is not required they got to call the employer and ask whether these people are employed, because if they ask next day, they won't be on rolls. They would be on rolls instead of on rolls. Right? That is why there is no need to ask. Law doesn't cast any such obligation for the department to ask and inquire with them. If they show the ID proof, it is okay and they can register it. And 50% of office bearers can be the outsiders. 50% of office bearers, as per section 22 of the Trade Union Act, should have been employees actually engaged in the factory. That is enough for them. As regards raising dispute, it is not only recognized union. Any registered union can espouse the cause and raise dispute. But what the court said is that in the event such dispute which is raised by this unregistered or unrecognized union, already raised and seized with the registered union, these people don't have right to agitate the same union, same demand. That is one. When it comes to the contract labor, there are different set of workers. The permanent employees, they are union only for that. Again, in the union, the membership is defined under the bylaws. The trade union is governed under the bylaws, which are certified by the Register of Trade Unions, who is the Deputy Commissioner of Labor or Joint Commissioner of Labor, as the case may be. In the bylaws, if they define under the membership any person employed directly on the rolls of the company or on the rolls of the contractor and indirectly working for the employer, such thing, there will be ordinary members, there will be honorary members. Honorary member is the one who is not on the rolls, ordinary member is the one who is on the rolls. And even if for the contract labor, if you look into it meticulously, you will be having 10 contractors, but the union is registered in your name, that X company contract labor workers union. And X company contract labor workers union is not valid as per law, because there are 10 contractors. Each contractor is a separate entity, and they have. So the persons who have subscribed from each union, there should be a separate union for each contractor, because the 7 members who have subscribed for registration of the union should have been actually engaged. But nothing is followed by, and they even go to the extent of CITU or BMS, statewide contract workers union. They open supermarket like branches. That is not also permissible. But no one to question, and that is simply accepted going. If you go into meticulously, that is not permissible as per law. So manufacturing has manufactured many questions, right? Yeah, just kidding.
That's the question. That is there any provision to prevent the contract labor unions registration? That's the question actually raised by the.
Yeah, I got Vijay Bhaskar, your point that registration of the union is a right under the in a democratic country. You can't prevent anybody from registration of the union. That amounts to unfair labor practice. And employer can be prosecuted for being unfair. They can fairly be prosecuted. Right, sir.
Police interference.
the manufacturer.
Yes, sir.
Is there any role of the police when the fatal accident took place in the industry? That is the question.
Yeah, it is quite often comes whenever accident comes more than their relatives, the local leaders, MPTs, MPPs, all those people come and say that you need to be paid lakh, 10 lakh, 1 crore. And subsequently the enforcement officials comes, revenue department, they say 50 lakhs. Then the police department, for revenue you accepted 50 lakhs, you give me 70 lakhs. Then SP comes up the department, when I came it should be 1 crore. So they will be going there showing the charity at the cost of others. First of all, he is not entitled for compensation if he is covered under ESI scheme. He need not pay single pay, even if he met with an accident in the course of employment, right? And most of the cases here, though they are not eligible, and they are being paid not out of mohabbat, it is out of majburi. Yeah. Sir, session. And another thing is that as regards the interference of the police department, whether they can interfere when an accident comes, because police do come and say that it is the negligence of the employer, they are liable for prosecution under section 304A of the IPC, therefore they can be prosecuted. And Factories Act comes that non-following the safety precautions and violation of the safety precautions, they have the power to prosecute under section 92 of the Factories Act, they do prosecute the employer further for non-following. Yes, and earlier there was a judgment of one of the High Court. What they said is that it is doctrine. A person cannot be prosecuted for the same double jeopardy. Sorry, it's a double jeopardy principle. A person cannot be prosecuted twice for the same offence. But again, the another court held that it is an offence under two different laws, like you see CBI case and Enforcement Directorate case. So they have the right to prosecute. So under section 304A normally there is another advantage of that, Under section 304A, normally employer is prosecuted for negligence and the police prosecute the case. And they file the charge sheet and it is a bailable offence, they get the bail. It is not that a non-bailable offence, it is a compoundable offence also. They can get away with the penalty, but some people, to make the things easy, they get themselves compounded and pay penalty. That compounding is enough for them because they are ultimately liable for prosecution under Factories Act because they have admitted and the guilt. So they cannot escape when it comes to the IPC. I am liable, I am guilty. When it comes to the Factories, I am not guilty. I am a hero. So one has to take care and keep in mind while getting that one compounded under Factories Act also. But in most of the prosecution cases, prosecution do fail in establishing the cases 99.9% because they are not acquainted with the industrial laws and other things. That you can take as an advantage for the Factories Act case. Yes, anything? And this police interference also comes in the IT sector because of the 498A cases, wife files and somebody maintenance cases, they just walk in and then the question. I think now only 20 minutes is left.
30 minutes.
Pardon?
30 minutes.
The 30 minutes. Okay. Because
questions related to UPH codes but we'll take it from the virtual.
but anything you can go by, we will complete it.
No, they want a detailed. I don't think we're going to have the virtual sessions.
Okay.
So I think all the new age codes, they are going to be addressed.
Yeah.
So that's the before handing over
we have
IT.
few questions of our.
Yeah, that's because we have to cover it. Rest of the questions in the virtual.
So it is related to both IT and service sector.
Yeah.
You can apply that.
Yes.
Just.
Yeah. Dual employment is moonlighting, fashionably called nowadays. Okay. And it is all happening during the COVID period mostly. And they are also becoming employers, employing some people under them and simultaneously logging and guiding them, a fresh graduate, taking up some freelance project and doing this. And how to put it is again a difficult question. The thing is that some of them would be taking wages directly from them. In that event, you can ask them to submit this Form 16A, the TDS, where the income from the other sources, other employment it comes. And in certain of the companies, even despite taking dual employment, they are also taking the PF pretty well. You can log into the PF UAN number and find out where he is elsewhere employed. And you must be having a clause in the appointment letter that during the course of his employment, he should not employed elsewhere. Don't say always competitor with anybody whomsoever. After leaving the company, it's a competitor. Even that is not valid as per law. But during the company, be it with anybody, he is not supposed to have any other engagement, because another engagement or employment, he will not be able to contribute to your organization either during working hours or beyond working hours. You may say that you bought my 8 hours. What if I work beyond 8 hours? But he gets exhausted over there. What if he cannot regenerate it? He loses his intellectuality, because especially IT sector, they mentally strain, not physically strain. In the manufacturing, they physically strain. The moment they go back home, they can have a sound sleep. Mental strain, you will not get sleep. It would be haunting me, haunting you even beyond. You would work beyond office hours also. That is why if you take extra employment, you get exhausted. That is not permissible. You must have a clear clause in the appointment letter, and you can show that as a clause. And certain people, they don't take, they will be taking in the benamis, because the wife name, son's name, somebody's name, they will be putting it. Then you got to look into it. That is the thing that what you need to look into. And another thing is that if there is so many people, he leaves the organization, and now there is other question. I will cover that point at that point of time. Yes, what more? Yeah, dual employment is illegal, sir. Yes, when you put it in the appointment letter, if you don't have the clause in the appointment letter, under the law, there is no prohibition of double employment. Specific provision of law is not there. But if you put it as one of the terms of the contract that he should not be employed anywhere during the course of employment with any other company or anything, then it is prohibited, and you can enforce your right. You would be violating the terms of appointment, and you can terminate him and ask him to choose one rather two. If it is not mentioned in the appointment letter, if we are silent, he can be violent. Legally well. Yeah, because law doesn't prohibit as such. The contract should prohibit where the law is absent. And where the contract prohibits, law should not, where there is no prohibition under the law, you can put where there is prohibition of law, you can't enforce under contract. When the law is silent, you can enforce under contract. Right. Yes, ma'am. Yes. And it all depends, and any person who is drawing more than 15,000 basic wage not entitled for the PF. He may be saying, I don't want to PF because you are being paid more than 15. I told you, for every law there is a flaw. He can be clever. Right. Pardon? No, when I am joining, if he is already a member, I am already being covered elsewhere. Why should I? He doesn't know I am covered already under that. My appointment here says that I am being paid 30,000 rupees consolidated. It is above 15. At the time, suppose if I joined at the 10,000 where I am covered, if I cross 15,000 rupees, then I should continue to be the member. Where I joined at the 30 itself, they say I have settled my account in the PF, and he need not comply with it. He is not a member. Yeah, he should remember that he is not a member.
Work from home, something related to work from home.
Yes.
Yeah, so COVID, people started working from home. And we have issued the offer, we say, leave workplace, whatever employer wants you to work is what the clause says. Now somebody doesn't want to come back to office. So does the employer have any protection from any legal aspect?
And if he wants to come back to office, if you put the appointment letter clearly, it is only work from home and he got no place in the office, he can't ask. Where you see.
You want the person to come back and work?
Yes, because his right of working is only at the office. It is only the option given to meet the pandemic situation. He has to come back and work. If he doesn't come back and work, you can as well initiate action. And it is only the option given but not mandatory.
second faction. I'm not terminate, we don't want to remove.
And by the same time, here the problem comes, you would like to have cake and eat it too. You don't want to lose the talent, by the same time you want to enforce your right. It is the fight between right and talent. Yeah, you have a right to terminate because it is a violation. Because there will be certain privacy issues, there will be certain violation of cyber laws and other things, security and other things will be there. It can be initially unauthorized absent. You say that you are no more permitted, you would not be giving your login ID and because he feels it difficult, he asked that question. Right.
Okay. Yeah, another point relating. When a person is released from some other organization, joined the new organization, but then something saying that my employer, old employer will give only after 30 days. Okay, but the person is joined and the old employer will put a case on the new employer, saying that how did you hire somebody without the relieving letter because he is not released from my place.
Yeah.
Can they do it?
Here the old employer can at the most sue his own employee, but he cannot sue a third party because there is no contract between the third party, new employer and the old employer, and that is not binding. Even if he sues anybody, that is he is liable for damages for suing wrongly, and only the employee is liable for that if he breaks the service rules or terms of contract, but the new employer is nowhere responsible. Pardon? No, first you are.
New employer has taken employee without knowing that he has been released there.
How can he? He ignored it. Because the need of the hour, he took him compromising, even though there is no relieving letter, he took it. He promised he would give relieving letter. Then the question arises is whether to lose the talent or terminate him. Then again the need of hour prevail upon the principle. 45 days you don't know what is that, they got to physically work or they can give the notice pay and buy out that notice pay and come out, you don't know. If they say that they got to 45 days, they got to physically work because knowledge transfer should be there. Without that, if he simply places papers and comes over here where the knowledge transfer doesn't place or where the replacement is not possible, then he may hold the relieving letter. And he might be having his justified causes, you are having your justified need. It is a fight between justified need and justified terms of contract. Legal in the sense where there is an obligation, obligate is not discharged, he need not even relieve him, he can even at that time initiate disciplinary action for breach of the contract and dismiss him instead of relieving also. If the relieving can be claimed as a matter of right, there is no contract validity, no? We can't pick and choose as per our this thing. So when he violates it, he can. Another thing is that certain times it so happens, employers themselves relieve them because they don't do well. You put them under PIP, Performance Improvement Plan. One fine morning you call them and say that here is the termination letter, here is the service certificate, which one you prefer? Task. And that is what I called as PPFT scheme. You know? Place papers or face termination. Place papers or face termination. That is illegal again. Sir, you have a question.
Yeah, during the initial phase of concealment of women, protect issues. What options the employer has?
None.
What is the option?
Yeah, I understand there will be a smart working, afterwards there would be quiet working, right? Quiet working due to the health reasons that we got to adjust.
Without relieving an employee or a letter, but whether he does not claim medical benefits and any insurance.
Mediclaim benefit is only purely as per the contract. It is up to you to extend it or not, or else you have to say that if he got to get any insurance benefit, it should be on the rolls. The moment he ceases to be on the rolls, either by way of relieving or by way of resignation or by a voluntary leaving, he is not entitled. Pardon?
You have not issued the leaving letter.
Even if he is not insured, he voluntarily abandoned it. How long? He is deemed to have abandoned, no? And you say that he is not relieved, you strike off his name from the muster roll, right? Then what does it amount? Your action speaks louder than voice, no? So if you want to show him on the rolls, you should continue to show him on the rolls until he is relieved. If you don't, if the moment you stop showing him on the rolls, there ends the matter. Sir, Ramesh Garinka. Any more questions? I over. You ask, we will ask them. Still, they have any questions? Because if I go to that, that will take long time.
Any more questions? We have under 5 minutes after that.
Where from the question? Huh? You are asking, sir? Yes. No, I got if the fixed term employment is every time being renewed from time to time, is there any liability? And because they also say the word unfair labor practice, FTE is recruited, fixed term employee is recruited to meet the exigencies, where to meet the contingencies, but not for where you have a permanent requirement. Renewing on them is nothing but depriving them from several benefits that are available under the legislation. Court may view it. It all depends how you put it. Also, you can justify it because your turnover won't be always fixed, productivity always won't be fixed. There is a fixed productivity, there is a variable productivity depending on the requirement. If you are able to justify it, then you can justify. I thought that this would be, and these exigencies do arise and continue to arise, you will have to justify it. Right. Experts. But they need to be paid full, and it is to be paid on this thing. That you have to ask department, because the act it is not mentioned. Yeah, there is a solution among your colleagues. This is more of the administrative work which I can't look into it. Otherwise, I would become an administrator. Right. Any more questions? Anytime you can, because within 30 days you can, the employer is liable to pay the gratuity. If it is not paid, forget about claiming gratuity. He can prosecute the employer. You can immediately prosecute within 3 months. He can prosecute, but gratuity claiming, he can as well seek the condonation of delay also. But usually it is condoned. Yeah, when he paid for a particular period, that insurance period in between he leaves and he is covered, and he need not pay. Insurance company would pay until unless there is a clause in the policy that he should be on the rolls. Because it is a group insurance. He is missing from the group, it is not an individual coverage. Somebody else joins in his place. And it is overall comprehensive policy. It is not an individual policy. So your question arises only in case of individuals where they fully paid and not availed of service. Right? It is very much, I told you, no, law is nothing but a logic. Answer is very much in the question. We only have to think logically. No?
You have the PPT to present?
If I start, that will take minimum 1 hour. That's why that's the reason. Then we will see in one of the sessions wherever on the virtual end or ending session, if we find time, we can cover it.
Any amendment on ongoing policy, what's the time and how early you should intimate? What is it? 45 days before, confirmation of the new law, or 60 days or 90 days? Any ongoing policy. If I change, let us say the notification today is 90 days, I want to make it 60 days.
First of all, what I mean to say is your policy is policy for yourself. Only when it is accepted by the other party only it becomes a contract. Mere offer won't constitute a contract. Offer concluded by acceptance constitute a contract. And you all people put HR manuals and HR policies, this policy, that policy. Sir, though the appointment letter is silent, sir, we have said in the policy that this is the clause. Whereas we have put that omnibus clause in the appointment letter, you are governed by the service conditions or that are enumerated or mentioned in the HR manual or handbook or whatever book it is, and you are governed. And not only the policy which is in existence, but also which may be amended from time to time, you will be governed. Such a contract is invalid because every time when you bring the change, at the time of joining, he joined and he knows certain contract terms. When you are introducing a new contract terms, he should convey his acceptance. Without his conveying his acceptance, he continued to bind the old terms. And other thing is simply giving appointment letter and putting a clause in it saying that you are governed, therefore you are governed by that voluminous HR manual, right from the joining to the separation and the selection to the separation, you can't. He should say and give a letter to you that he has gone through the HR manual, fully read, understood, and conveying his unequivocal acceptance for all the same. Then he has to, and he has to acknowledge it also, that HR manual. Otherwise, they took the signature and he did not give me. So it has to be, in most of the employment contracts, I do say in appointment letters also, everybody puts their autograph in the last page. First page and second page, third page, they don't sign it. Because they may attribute tomorrow that you have changed and replaced the papers. Even in the contracts, everybody puts the signature on the last page. And many cases do come to me for suing the employees for violation. Only the last page signature is there. Once I told you can take all these pages, what are the clauses in the last page? If at all there is a right, I will sue you. For the rest of the papers, you can put it in your waste paper dustbin. You have to take acknowledgement. That is what. Service is different from that of acknowledgement. He has to acknowledge it. Who knows it? Because when the moment he signs, it is as if it is supplied only. He has to he has not given me the copy. Otherwise, there will be implied. Implied is complied. I am simplified. Right, sir.